Welcome to Breaking Down Mental Health with Dr. Jones. In these educational videos, Dr. Jones will discuss mental health diagnosis, clinical supervision, using technology in counseling, multiculturalism, and many other topics to help you get a healthy understanding of why mental health is important. Please don't forget to like, subscribe, and hit the notification button if you enjoy these videos. Hello everybody, my name is Dr. Jones. Today I want to talk to you about a topic that may cause you a little bit of anxiety, but it's my hope that once this video is over with, your anxiety will be a little less because of the information that is presented. I want to talk to you about what it looks like to go to court and present yourself as a therapist and how to prepare yourself for that process. Usually whenever you go into court, there are two different roles that you could partake in. One role is what's called a fact witness. When you think about a fact witness, this is someone who's providing information about their direct interactions with a client. This is where you'll be talking about the progress the client made in a session with you, maybe the diagnosis the client has, or a treatment plan that the client has. But the most important thing about this is we're focusing in on facts. I'm not giving my opinion about anything. I'm still simply stating what has been brought forward to me in a counseling session and saying that in front of a court of law. And so that's what a fact witness looks like. The other reason you can be brought into court is what's called an expert witness. This is where your specialty area that you have may be called upon in a court case, and a lawyer is looking for you to speak about your expertise on a particular topic. This may mean you're looking at psychological data and interpreting that for someone, or talking about certain mental health concepts to help the court understand them, but they're looking at that from your expert opinion. And so either whether you're a fact witness or an expert witness will really kind of clarify how you end up going through this process with the clients that you're working with. One of the first thing I will always suggest you do, regardless of what reason you're going into the court, is make sure you understand your records before you go in there. I'm a big proponent of making sure that you're always prepared before you go into the court case. So if you're going to be a fact witness and you're going over clinical records, make sure you're familiarized with them. Make sure you've read through them several times before you get into the courtroom. That way, if a question is being asked of you, you don't have to necessarily refer directly to those case notes because you're very familiar with that information already. But what's really important about these, as you prepare to review your records, you want to make sure that everything you talk about is clear and factual and objective. And what makes things the best when you think about things being clear and factual and objective is that you're going there basically to give back information that you've already received and to be able to portray that in front of the court of law. And so when we're doing this as a fact witness, I want to simply remain close to what is documented. I don't want to give my opinions about it. I don't want to speculate about anything. I simply want to make sure I'm giving back to the court of law and specifically to the judge there the information that's already been presented to me without me putting in my opinion on top of that. And so the reason why this is important, everything I talk about in the court of law, I want it to be something that can be verified. So if they ask me about the number of court times the client has come in, I want to be very specific about that. Know that I've seen them maybe 12 times, 13 times, wherever the case may be, but I want to make sure I'm giving them specific facts about that. And the reason why that's so important is because we don't want to speculate about anything that we bring forward to them. So I always say, make sure you know your records well, read them before you go in there, practice with them. That way, when you're asked questions, you know exactly what you need to say and be able to say it and speak on it factually. Another thing I'll also suggest is making sure that you consult some legal support. For all of you, you should have some type of liability insurance prior to practicing. So if you're in field experience, you'll get some liability insurance at that point. You continue to carry that liability insurance on throughout the process of you being a mental health counselor. And the reason why this is important, if you get called into court, you want to make sure that any legal documents that have been sent to you, you want to make sure those legal documents have been reviewed by another lawyer. That way, there's a way for you to be able to understand what can be said in the court of law and what can't be said in the court of law. And the best way to do that is to consult with another lawyer or legal counsel. And this helps out quite a bit because the liability insurance that you have will most likely have a lawyer on staff who's familiar with counseling laws in the state that you're in, and they can give you a very clear picture of the things you should and should not say before the court of law. And so I would definitely make sure that I'm talking to my legal counselor about that. If you have a supervisor, I definitely want them to get involved in this process as well, so they can give you some guidance as well. And like I mentioned before, get in touch with your malpractice as an insurance provider. That way, there's a very clear line of communication between everyone who's involved in this case. And that way, you can go in there and not being influenced by anything on the outside, but knowing that the things you're talking about is going to be helpful to the client that you're testifying for or testifying about. We also need to make sure that we're being aware of HIPAA laws as well. And when we consider HIPAA laws, we want to make sure that the things we say in there, that we're not talking about confidential information and being very clear about the things we can talk about and things we can't talk about when we're in front of a lawyer. And so HIPAA really helps us to guide that, and you will understand more and more about HIPAA throughout this program, and then also in training beyond this program. But you want to be mindful what HIPAA says about what you can and can't say when it comes to clients' records. And also, before you go into court, you want to make sure you verify who is requesting your testimony and whether or not you're legally required to do that. Depending on how you're viewed in your state. In some states, you may be considered, when it comes to your communication, it may be privileged communication. And so if that's the case, you may not have to go into court at all, but you still want to make sure before you go in there, who is requesting information and what specific information are they requesting, and looking at that from a good view before you go in there. That way you stay within the boundaries of the things that you know you can and can't talk about. Now, we've talked a little bit about the legal aspects of it and talked about how to prepare yourself when it comes to the court case. Let's think about your courtroom etiquette. One of the things we have to remember is as we go into a court of law, we want to present ourselves professionally. So part of that, we want to make sure we're dressed professionally. So I think a good thing to look at is visit court sometime, look and see what the lawyers are wearing and things of that nature, and make sure you're dressed, the things you're dressed in are also in accordance with those individuals are wearing as well. And so make sure that we're wearing something that's neutral, something that doesn't really stand out quite at all, because we want to make sure that when we go in there, I'm not trying to draw attention to myself. I'm just really there about the court case that I'm there for. And so just making sure that the things that I'm wearing in court is dressed professionally. Also, making sure when I get in there and I do have to speak about anything, that I speak clearly and concisely. And so I don't want to get in there and ramble off or anything. I really specifically want to talk about the things that I came in there for, speak very clearly about it, be very concise, and not only answering things or asking me questions about. That way, when I'm there, I'm only there to provide information I'm there to provide. And also just been remaining calm and composed. Being in a court of law, sometimes it's nerve-wracking. It can cause a little anxiety for you. But I would just say remain calm, that no one's there to harm you. Now, you may not like being cross-referenced or things of that nature. It may not be comfortable for you, but at the end of the day, you need to make sure you're remaining calm and stay composed the entire time you're there. Now, one of the most interesting parts about going to court is handling the cross-examination. One thing I want to remind you of is that it is a lawyer's job to frustrate you. It's also a lawyer's job to get you to say things they're wanting you to say. And so you can either go in there defensive or you can go in there understanding that's what their role is. And so since that's their role, I want to make sure that I'm staying composed and only ask and answer things that they've given to me. And so I try not to go outside that scope of what they've asked. I stay right in the zone of the things of the question they ask. And once again, I do it very concisely and get to the point as quickly as possible because I want to make sure that things I'm saying are very much backed up by fact and it's not in me putting any conjecture or my thought process behind that. Also, pause before responding. Anytime a question is asked, take a second, think about what your response is going to be, and then respond afterwards. That's going to help you to be able to be very clear and concise in your thoughts. And also to avoid being defensive. Once again, the things that the lawyer may say to you may be something that will get you nervous or maybe cause some anxiety for you. And I would just say, don't get defensive. They're doing their job. Even though it's not comfortable for you, they're still doing the job they will set out to do. So just try to remain calm as quickly as much as you can. Also, just making sure that we can be mindful of the ethical considerations and confidentiality. We're still bound as therapists to remain confidential as much as we possibly can. And so there may be times where you're in court and you're there against your client's wishes. And whenever you're in those type of situations, make sure as you're talking about the things that you're there for, that you're being very neutral and everything you're saying is based on facts. I can't emphasize that enough, is that you must remain neutral and everything needs to go back to the facts that you have right there in front of you. And that's why you prepare before you go into the court as well. And I'll also say avoid having any type of dual roles when you go into the court system. That means if you're there as an expert witness, you don't want to be an expert witness on anything that has to do with any of your clients. So if you're there for to talk about facts, talk about those facts that have to do with your client, but don't also be in a role there where you're also an expert witness as well. You want those roles to be separate. That way you're only providing one role for your client, and that way you can avoid any type of dual relationships. So once again, being in court is not always fun, it's not always comfortable, but it's sometimes you will be called to do that. And so it's my hope that this video has helped you to feel a little bit more confident about stepping into this role as a counselor and going into a courtroom and talking about things that are confidential, but also making sure we stay together and realize that the facts are what will set us free in this. Hope you're doing well, and I hope this video was helpful to you.